Have you had an employee recently file a workers' compensation claim? Stay tuned, we're going to give some really good tips for employers on navigating the process. So I'm here with Brenna today, and we're going to be talking about 3 tips for employers related to workers' compensation. So I think the first one to start out with is, what should an employer do if they have an employee come to them and say that they're injured?
Yeah, I think the first thing to do is just not panic. Don't immediately jump to the worst conclusion. Make sure you understand what you don't yet know. So you want to, as an employer, when someone reports an injury, you want to make sure that you get context. Is this injury work-related? When did it happen? Maybe they've been carrying these symptoms for months and they just haven't mentioned it to anybody yet. So you are really that first responder in the sense of being in the best position to get information from the employee. You want to protect their privacy, you want to respect their privacy, but as an employer, you are able to ask them, what's happening? What hurts? Where do you think this occurred? And do you think it's work-related? And then at that point, if they do say it's work-related, or if you have knowledge or it's clear that you should know it's work-related, an employer should be providing them with a DWC-1 claim form. And if there are any questions about whether the claim form is owed, immediately contact a broker, contact an attorney, contact your carrier representative to make sure that you're doing the procedures correctly.
A question my team always gets asked is in regards to subpoena. They get it in the mail, they're like, oh my gosh, we just got a subpoena. How do we respond to this?
Yeah, well, if they recognize it as a subpoena, they've already won, because most people get this very legal looking document with a lot of stamps and seals, and they're just like, I don't have time for this. I'm gonna go grab a Starbucks, move on with happier things, the better part of my day. Then weeks later, it surfaces in a drawer or on a to-do list, and then counsel might get it, and the production date has already expired. So if you get a subpoena and you recognize it as such, you should be immediately forwarding that to your broker, your carrier representative, or counsel, so that we can appropriately respond on your behalf. Also, whenever you get a subpoena, you should look at the top right corner of the first page. There should be an ADJ case number. The legal authority for a subpoena for production of records and documents comes from the WCAB, so the Workers' Compensation Appeals Board, filing of a case by the injured worker. If they haven't filed a case, there's no legal authority for the subpoena and no production or response is necessary. But you want to make sure you communicate right away, because if a production or response deadline gets passed, and if you had an obligation to produce documents or information, you may be opening up your entire file, privileged attorney-client information notwithstanding, and have to produce all of that information.
That's great information. And then lastly, what do you think is the largest mistake that employers make when it comes to a workers' compensation claim? And I know it's hard sometimes just to pick one, but what do you see?
Yeah, I think employers now are a lot more savvy than they have been in the past, and they know what they don't know, right? So you know to ask the questions, you know who your communication pipeline is, and I think that's the most important thing, is just whenever there's a gap in your knowledge, if you get a document you don't understand, if someone asks you a question and you're not sure how to respond, make sure that you're communicating with your broker, with your counsel, with the carrier representative. But just understand that as an employer, a lot of this can be very daunting, and if you don't understand the process to a T, make sure you are asking those questions of the right people, so you're getting good advice in a timely way. The worst thing you can do as an employer is sit on information, sit on documentation, and just hope it goes away, because as we know, it doesn't go away.
Well, and I think another piece of that comes when you're communicating too with the employee. I think a lot of times employers skip over that. They think the insurance carrier is doing it, and I feel like sometimes that's a failure because the insurance carrier isn't necessarily talking to your employees. So you still want to have those regular conversations. Is that correct with your employees?
Oh, absolutely. And if you're not sure what to say, talk to your broker ahead of time, and they can really guide you as to how to have those conversations in a respectful way with the employees, that you're respecting their privacy, you're protecting yourself from a lawsuit related to HIPAA or any of those other concerns that might arise. But you don't want to stop communicating because you're afraid. It's going to lead to more problems at the end of the day. And I think a lot of employees litigate because they don't feel heard. They don't feel listened to. So they go to an attorney so somebody will hear them. And a lot of cases get litigated that don't really need to because there's a lack of communication.
Absolutely. We really appreciate your time today, Brenna. These were some great tips for our employers. Thank you.
Thank you so much for having me, Carrie.